Shenkman, joined by my friend and colleague, Alan Gassman. He got the memo, so we both wore blue shirts, no ties. We're going to just talk about potpourri of different ideas, techniques, things that are on our mind as we approach the end of 2025. We kind of build this as, clever ideas to talk about at one of your many holiday parties. I'm sure at least one of the points that we discuss will be of interest to all your family and friends when you're having cocktails over the holiday season. Alan, one of the things that I know we've spoken about, but I think it's just worth talking about very briefly, and you can talk as much as you want, is there's a benefit to some to make charitable contributions this year before the end of 2025. So that's certainly something people can still do. You want to chat about that a little? We can do non-grantor trust after, because that's really separate.
Sure. Well, charitable giving is going to be more complicated in 2026 because of these silly rules. This 0.5% of adjusted gross income cutback is going to cause a lot of confusion. So,
and don't leave out the 237s. That's my favorite change.
Yeah. I've got to pull out to understand it. The computer systems don't understand it yet, but it's just going to be a little bit more complicated next year for a large donor, right? So just get it done this year, get a slightly bigger deduction, and you know the deduction you're getting.
Yeah, even Bob Keebler, who's a brilliant guy, said that it's become so convoluted with all the different phase outs, phase ins, caps, and they're all different and they're all inflation adjusted. He said that the only way to get numbers right is to go to the software and do a forecast. He says you can't, it's really impossible at this point. It's kind of been for a while to remember all this stuff off the top of your head. Alan, the 237s is a reduction when you hit the highest income bracket. And I know there's been a lot of talk, and I don't want to get into it very deeply because it's just, I don't think there's an answer. I just think we should confirm for everybody. Does that apply to trust? Does it not apply to trust? I don't think there's full agreement on it. I think it remains sort of a murky area.
I agree, but I will tell you that Marcia and I are establishing an irrevocable trust. We're going to put bonds in it, and the income from those bonds is going to go to charity. And I'm going to take the full deduction because the way I read the code, there's a full deduction there. So others may disagree. The IRS may agree or disagree. We'll see where they come in. The law's not absolute.
They haven't come down with anything yet.
No, they haven't come down with anything yet. But they may come down taxpayer friendly. It's a little bit different political climate right now than it.
Well, it's also the administrative burden to even administer this stuff. Can you imagine? So there is a benefit to doing charitable giving this year. For those that want to do something at the last minute, you can set up a donor advised fund pretty much like that. You probably even do it online. I've never done it online, but you probably can. So there's certainly last minute charitable giving that clients can do, especially if they're realizing or recognizing rather gains on some of their highly appreciated stock positions. Alan, you kind of mentioned a non-grantor trust, I'm assuming, in the bond portfolio. You said you're putting in a trust. I know we've all talked about that, but maybe give just a couple-minute overview of why that makes so much sense.
Well, we have a vacation home, and the property taxes on it are $26,000 a year, which I'm not going to be able to deduct.
That's because you don't live in New York. You should see what ours are.
Right. So I'm not able to deduct that on my return. But if I put that property in a non-grantor trust and I put bonds in the non-grantor trust that cause more than $26,000 of income that otherwise would have been on my personal return, then that bond income can go into that trust and pay those property taxes. And that'll be the equivalent of deduction. It's deductible by the trust. And then we'll put more than that in bonds in the trust, and that excess income can either go to charity, and I believe it's 100% deductible, but even if it's not 100% deductible, it's 90.
237s is so inconsequential. I mean, I think it's going to be a big number on some really large charitable trusts, but for most people's planning, it's not going to sway the needle.
The math causes you to only be able to deduct 35% instead of 37% federally. That's what the math came out to. But the other thing is that trust can spray income to our children, nephews, nieces, and things like that. People who are in a
What
lower
about your favorite lawyer?
our favorite lawyer.
I'm not in there.
Yeah, yeah, I'll send you $6 or $7 or something like that. But that's a fairly simple non-grantor trust application where I can feel like I saved $5,000 or $6,000 a year of income taxes or more. That's worth doing.
I think it's a phenomenal plan, and I think it's a great planning tool for lots of what I'll call moderate wealth clients. It's not only looking at estate tax savings, this is an immediate income tax saving for lots of clients. Let me just clarify, because I know what you had in mind, but when you say simple non-grantor trust, for an estate planning specialist, it's a simple non-grantor trust. If you have somebody that's trying to go online and draft their own document, and I don't think anybody on this call wants to hear somebody like that become a client. But if you have somebody that's trying to draft it on their own, I know that some of the financial advisors have software that permits them to draft documents. I think a non-grantor trust in this kind of planning, while certainly the financial advisors should be involved in encouraging and understanding and discussing with clients, because I think it's a great tool, you really need a specialist to draft it. And one of the issues that arises with non-grantor trusts, I like the most flexibility we can, and we're going to talk about flexibility in non-grantor trusts from a different lens that I've never discussed before later on. But I like to have a spouse, if the client is married, included as a beneficiary. But then as a spouse, it's going to be a grantor trust unless an adverse party, recorrect that, adverse party has to approve the distribution to the spouse. That's not so simple. And I'm not sure that something you get online is going to really even address something that nuanced. And we've talked about it in other programs, so I won't belabor it, but keep in mind that if you have an adverse party approval, let's say a child and spouse are beneficiaries, the child has to approve a distribution to the spouse, so they're adverse, maybe. Also document that. I don't think I've ever seen anybody but me try to document. I've seen lots of non-grantor trusts, but you want to make sure there's something, even if it's just a simple document signed by the child as the adverse party. Yes, I approve this distribution. So you have something in the file if it's ever challenged. And keep in mind, it's not only a challenge potentially by the IRS, it's also potentially by a creditor. And while the IRS has been really, put through the ringer with current funding and financing, I mean, there's no assurance that even in the near term, that's going to continue. We could very well have an invigorated IRS more aggressively collecting revenue. And nobody really can anticipate how AI is going to revolutionize what the IRS does. They may be able to do much more strategic and focused audits with less people just using AI. So be careful with what you do. Make sure you address the adverse party. And another nuance on the adverse party, Alan, if I have a kid and the kid and my wife are beneficiaries and I want a distribution to my wife, if there's a regular pattern of distributions that he approves without ever saying no, does that suggest there's an implied agreement?
I don't know. I don't think I would give up hope if that happened. I mean, the fact is, he better allow her. He's or she's going to disinherit him from everything else. So I don't think it's unusual.
And by the way, if you look at some of the case law, and it's all pretty old, if there's screws on the so-called adverse party, so they really have no choice, some court cases suggest they may not be adverse. But again, those are the nuances that I think you need a specialist involved to address with. That doesn't mean the planning can't work for a wide swath of people, but I think it's more nuanced than just going online or going to your software package as a non-attorney and printing it out. I think, this is like those commercials where it says, close course, professional driver, don't do it on your own. I think the non-grantor trust plan requires that. And that doesn't mean it has to be expensive. And as Alan said, for estate planners, it's not that complicated. Alan, what else would you like to talk about?
Well, before we get off the charity, time after time, a client comes to me and says, "Oh, I was told that in order to have my own family foundation, I need to have at least $5 to $10 million in it, and then it's going to cost me $10,000 to $20,000 to form it. And it's so hard to do the tax returns, and it's very complicated." And that's just complete balderdash. You know, if you have,
Balderdash. It's a good word.
yeah, whatever that is, whatever that word was.
It's a polite term, though. It's good use.
Yeah, yeah. You know, what do you charge to set up a not-for-profit trust or a not-for-profit company? There's only 6 or 7 variables in the documents. Let's not be charging people a small fortune to set up a simple 501(c)(3) charitable trust that mom and dad can be the grantors and trustees of, put all the IRS required language in it, give it the name that they want to call it, let them put their appreciated securities in there, get a tax deduction, and say that they have the John and Martha Stewart Foundation. And yeah, they'll have to file a Form 1023, which looks like all the other Form 1023s. It's not a complicated thing. The IRS approves them, and then you file a Form 990, which is easier than a 1120S. You make sure they distribute at least 5.5% of the value per year to charity. And then there may be a great passion found by that family in knowing that they have a foundation, and the children and grandchildren get involved, and people in the community hit on them for donations. And it's a nice thing. So I just think telling a family, no, it's too expensive, it's too complicated. It's not as complicated as the channel changer on my television, which I can't even get to work half the time. Marcia's got to find the channel, find the movie. How do you get to Netflix? It's easier just to do a not-for-profit. So I understand the donor advised fund is great, but it's very vanilla. You can't do anything but write checks to public charities. You can't go help someone who needs help in your community. You've got to just write checks, which to me is just not really what charity's about. Or yeah, it's great to say we'll use the community foundation, but does the family really want the community foundation all over them? And I got to have lunch with the community foundation, and the community foundation is hitting the account for 1% a year and suggesting what I should do. I'll just have my own darn foundation. Thank you. Do you think I have strong feelings on this?
No, not at all. Not at all. But I think the broader picture is certainly with technology, drafting software, projection software, we can do a lot of things much more efficiently than we used to, and give much better service and more robust services to clients. I'll give you an example that's a little off touch, but I had a client yesterday email me, and he said he wants to do something with a loan that he had made to an irrevocable trust. Now, Alan, how many clients have made loans to or from irrevocable trusts in the last 10 years? This could have been 7 years ago. I remember the guy, I remember the loan, but I don't remember anything else. So just for kicks, I went into Copilot, because all of our data is stored in Microsoft's 360, Microsoft's cloud, SharePoint. And I said, hey, Copilot, I had this client, here's his name, and he had some kind of loan to a trust or from a trust. See what you can find me. And before I could get a cup of coffee, I had a summary of everything.
Wow.
I had links to the documents in my system. And basically in a half an hour, I'm all ready to go to talk to the guy. And I have everything handy. And just for kicks, AI said, would you like me to write a client-facing summary of all this information? I said, sure. And then AI said, would you like me to write a document to terminate the loan? I said, yeah, go for it. Now, I don't know, I'm sure I'll tinker with the form a little, but wow. So we can use, when Alan is saying that we can do work like a foundation more cost effectively, it's not just that he's so smart and good looking, which I have to acknowledge, but we have tools that we never had before. The key is intelligently using those tools. And the flip side of what we're talking about, and I've seen this, I would almost say it's an epidemic, and I had this yesterday too, and it was very frustrating. A client emailing me, not beginning to understand what I've done for her, and complaining about the bill. Well, she came to me where she had a whole plan worked out by her financial advisor, but it didn't address any of the real issues. And by the way, Alan, you certainly won't remember, but when we were tinkering with Estate View, we did a analysis of an irrevocable trust that this client's family had. And the client didn't want to authorize me to review it, so I didn't review it. But for just to see how Estate View analyzed the document, I put it in. There's some really significant bad things in this trust. A supposedly GST exempt trust that the kids get paid out at age 30. Who does that? But that's what was there. And I found it in 5 minutes with Estate View doing a summary. So the AI functionality, folks, can transform how we practice. So don't dismiss what Alan is saying. Look at the technology that we have and figure out how to adapt it in ways that are creative and clever. I got a topic if you don't have one, or you can do one.
Go for it.
So one of the things that I see, and I would dare say it's, and I have no statistics, but I think it's the norm. Alan, how many transactions do you do, or what percentage of transactions do you see that have like a Wandry or some type of valuation adjustment mechanism?
Nowadays, probably 70% of them, or 80%.
Right. Yeah. Different people have different views. I agree with the school of thought that, gee, if you don't really need it, why do it? It only makes it more of a hot audit button. But on the other hand, I really agree with the school that if I'm at an audit and somebody is challenging from the service what a value is, I'd rather have something to throw at them than nothing to throw at them. So I think it's pretty common to see these defined value mechanisms, certainly in larger transactions. Maybe if I were doing a much smaller transaction, I'd skip it just to keep it simple because they're way below the threshold. But for any substantive transaction, I would include it. I don't see when the statute of limitation runs, people going back and correcting their records. So in other words, I sell an asset to a grantor trust and have a Wandry clause. File a gift tax return, adequate disclosure, 3 years pass. Most people seem to do nothing. I have no statistics. There are no statistics on this. The banks continue to show on their records that there's whatever percentage of membership interest, and somewhere in their files they have indications of a defined value mechanism. If the accountant, and a lot of times they just do it wrong, even when you tell them, because sometimes you're talking to the T&E people at the accounting firm, and this is maybe the corporate people filing an 1120S. They never talk to each other. I don't know why. They're partners. They should like each other, but they never adjust the K1s to get rid of the statement that says this is subject to a valuation adjustment mechanism. So it's important to remind clients, hey, if the 3 years has passed, get rid of those adjustments and show it as a fixed percentage or number of shares or whatever it is. Get rid of the defined value caveat on the language on all your documents. I think that's important to, first of all, it simplifies everything. Secondly, it makes it less susceptible to someone looking at it and saying, what is this? And third, I think it's part of adhering to the formalities of the defined value mechanism, because pursuant to the terms of, say, a Wandry clause, after the gift tax statute of limitations is told, you don't need this. Alan, comments, thoughts?
Well, for those viewers who may not be up on Wandry, and what Marty's saying is, if I give a 99% non-voting member interest in an LLC, say I put $1 million worth of assets in the LLC, I take the position that 99% non-voting member interest is worth 6.5 million, 35% discount. But if the IRS audits it, I don't want to have to pay gift tax. So I say I give a percentage based upon what's
dollar
worth,
value. $1.5 million.
Right. I give $6 million, $6.5 million worth. I think that's 99%, but it may be 88% if push came to shove. So in the Sorensen case, the IRS came after the two guys who established Firehouse Subs. Now, I always thought it was Firehouse Subs because it was like really hot subs, but it turns out these guys grew up, their father was a fireman, so they called it Firehouse Subs. In any event, they transferred Firehouse Sub ownership using the Wandry clause, and the IRS came in and said, you guys did this all wrong. Your financial statements, your tax returns, they show that you gave the 99%. They don't show that you gave a fraction. You should have put footnotes here and footnotes there. So now I guess the safe thing to do is when you've used a Wandry clause, you should put on the stock certificate. We think that this is 99%. It might be less. Put on the financial statement. We think it's not. I personally I don't agree that failure to do that is going to cause the Wandry clause not to work. So I'm a renegade in that arena, Marty. But yeah, I think.
Am I allowed to disagree with you?
I think almost nobody's doing that. And I don't want to imply that the standard of practice is that if you use a Wandry clause, you have to do all those disclaimers. But I do agree that if you did do it correctly, that it's best to take those disclaimers off after the 3-year period. But then let's talk about using a King clause instead.
But let me comment before you go to segue to King. So I don't disagree with Alan, and he's actually correct. The Wandry case itself, I think the K1s were incorrect and did not list that it was subject to a dollar valuation transfer. That being said, the fact that the taxpayer got away with it in Wandry is not what we should shoot for. And conceptually, or big picture, I feel we should always strive for perfection, knowing we're never going to get it. You can't do any of these transactions without some foot faults. I think it's fair to say it's absolutely impossible. And given that, you don't know how many foot faults it'll take for a court to go, maybe that just doesn't work. So I think you want to strive to disclose it everywhere you can. The more you do, the better. And give me a minute, Alan, because I want to explain some of the consequences of overlooking this stuff. And I do think you want to adhere to the formalities. Does everyone do it? I think Alan is correct. Very few people do it, but that's not a reason not to strive for better compliance. And I think it is important. And I think that the accountants preparing entity returns in the accounting firms have to walk down to the proverbial water cooler and talk to their partners on the T&E side and make sure they know if there's a Wandry clause. I think trust companies need to flag any trust that has assets subject to some type of adjustment mechanism, so that they at least have a reminder before they do something. I just reviewed a transaction, very, very large transaction. And in the transaction, they had done a tax-free merger of several companies. The corporate counsel never called me. They ignored the Wandry clause. So they listed in all the entity documents for the reorg the number of shares that they believed were owned. But here's the problem. We have many layers of active Wandry clauses for all these various prior transfers, from note sales to gifts to all sorts of things that are still alive. And they need to have 80% of the target company acquired in order to have a tax-free reorg under 368. How do they know they got 80% if it's subject to all these Wandry clauses? Now, the solution to the problem would have been really, really simple. I think all they had to do is have the transfer settlor client sign the reorg documents saying, hey, if I own anything under these Wandry clauses, because of these Wandry clauses, I'm transferring it as well. Then they would have gotten their 80%. They didn't do that. So they could have a massive income tax consequence because of the uncertainty of what the Wandry clauses do. So it's really important to address this stuff. I agree with Alan. I don't think it's certainly not a standard of practice. I don't even think it's the norm, but I think that's the gold standard we should strive for, not the standard of practice. Tell me about King.
Well, the King clause is, instead of saying I'm giving a percentage of the company equal to 6,500,000, I'll just sell that 99% non-voting member interest to the trust for a $6.5 million promissory note. And the agreement and the note say, if it turns out that this 99% is worth more than 6.5, then the trust owes me more than 6.5. And if it turns out it's worth less than 6.5, the trust owes me less than 6.5. And any adjustment will also have an interest rate payment as well. And there was a court case that approved that in one of the circuits years ago.
I think it's 11.
Yeah, And the
But I could be
reason that
wrong.
the reason I prefer the king clause, number one, I prefer it because you don't have to worry about the financial statement disclosure, except you'll disclose that the note may be more or less. But secondly, you get the full benefit of the 99% transfer. If it turns out I only get an 80% transfer instead of a 99% transfer, then I've left 19% of the growth and the income of this entity in my estate. But on the other hand, if I end up with an extra promissory note of $1 million at the applicable federal rate, then it's just a better transaction to avoid the estate taxes. And then the other thing is, the IRS hates quandary clauses, hates quandary clauses. No mention of king clauses anywhere. So maybe there's a chance that an auditor looking at this, or an IRS attorney looking at this, would be, less threatening to the structure.
So a whole bunch of comments. First, there's another aspect to what you just talked about that's really important, that I think is one of the more overlooked issues with all these quandary clauses. It's not just that you're leaving some percentage of the growth, appreciation, and asset possibly in the client's estate, but aren't you setting the client up for a Powell or Moore case argument? The client, in conjunction with others under 2036A2, controls distributions, liquidation, whatever, and now you have potentially an argument by the service, not just that the value's wrong, so something's in the estate, but because anything is in the estate, you now have under Powell an argument that they still, in conjunction with others, control things. The whole thing is back in their estate. And it seems to me the King Clause avoids that. What I've done to address this Powell-Moore issue when I've used quandary clauses, and I shouldn't admit this on tape, but I think the King approach is much simpler than what I'm going to do. So if you want to have a more complex transaction, which I like, you could do the following. I'll do a follow-up sale. So in other words, if I'm selling to my grantor trust $10 million worth of XYZ stock, estimated to be whatever percentage of it, I will sign what I call a secondary purchase and sale agreement on the same date, same time, saying, if I own any of XYZ stock as a result of the quandary adjustment mechanism, or whatever adjustment mechanism you use, I sell that today at the same time for the gift tax value finally determined to the trust, and that a note will be issued with interest retroactive to today, so that if the IRS is victorious on a quandary clause, I've gotten rid of all the stock regardless, and I will pay whatever is necessary on a note based at gift tax value finally determined. But this way I've completely, I think, eliminated a Powell-Moore argument that I still control something. And the other beauty of that approach, which is why I like it, Alan, and I'm going to come back to the King in a second, is that the complexity of administering these valuation adjustment clauses, I think, is also probably more overlooked than the disclosures on financial statements and K1s and everything else. How so? If I sold 10 million of stock that I think is 80% of the company to a trust, and there's an audit 2 years from now, and 5 years after that the audit settles, how do you adjust for all the stock that's back in my name for those 7 years? It's complicated. And I always include an economic adjustment mechanism and just kind of punt it to whoever the then certified public accountant is for the entity to make the calculation. But if you have the secondary purchase and sale agreement approach that I use, there is no adjustment because the trust owned everything from the get-go. And on some really large transactions, I've actually done the secondary sale to a different family grantor trust so that they can't aggregate it. Let me make it even a step more complicated. And then I want to come back and give a few comments on King. When I have a really large transaction, and I'm not going to define it because it just depends on how the client feels about risk, how you feel about risk, whether you need to, get that vacation home that Alan has and you need to bill more. But what I'll do is I'll use different mechanisms on the same overall plan. So in other words, I may have a spillover to a grant or charity, and you got to be mindful of the grant because there's a CCA about valuation. But I may have, let's say, two separate grantor trusts from husband and wife. I may have a third grantor trust that one of them sets up. I may do a note sale to one, a skin to another, an annuity to another. I may have a defined value clause using Wandry on one. I'm blanking on the name of the one that spilled over to charity. What's I'm blanking on the name.
Like
What?
Christensen?
Yeah, Christensen or Petter.
Yeah.
And I may even do a king clause. I like to mix it up because if an auditor comes in and they're looking at the whole transaction, I want them to, first of all, what if there's a case or a CCA that comes out that negates a plan that I have? If I have 3 or 4 different techniques, and we've worked on stuff like this, Alan, I think it's much harder for the IRS to come in and make one argument and undermine the whole plan. Now they got 3, 4, 5, 6 different techniques. They got to fight them all. And if one of them is held questionable by a court case, after I've done the deal, I have other techniques. On the King case, Jonathan Blattmacher, I remember, argued with me strenuously, and you know how animated and passionate he can get, that Wandry is a tax court case, and King is just, I think, 11th Circuit. I may have the circuit wrong, but it's not a full tax court case. So Wandry has more credibility than a King clause, and he was giving me a really hard time. Don't tell Jonathan, and I'm not going to let him see the video, but I still did my King clause because I like it. Steve Gorin, I've had discussions with, and he's a bright guy about the King clause. He loves it, and one of the reasons he loves it is one of the reasons that I like it, and I think it's probably one of the reasons Alan didn't say that he likes it. King clause is actually used in real business deals. Real people doing non-estate planning transactions use note adjustments in case there's a difference in revenue or value or something on a deal they've done. It's a real thing. Wandry is really only lives in the estate planning world. So I too like the King clause, and I especially like mixing them up when we're doing larger transactions. Alan, you got another topic I want to talk about at some point, FTC.
Let's do it.
Okay. So if you're doing a large transaction, and forgive me, I meant to look up the number and I didn't, but it's about 120, maybe it's $126 million. If you're doing a large transaction, you need to make sure to hire FTC, Federal Trade Commission counsel, to look at the transaction before you consummate it. If the transaction involves a transfer, and I think the number is about 126 million, it's something in that range, you may be required to make a filing with the FTC. And if you don't file, the penalties, I think, are over 50 grand a day. And if there's multiple people involved, you could have hundreds of thousands of dollars per day in penalties. And if it's willful, I think the client can face a $100 million fine and a year in jail. I've never, I would like to not imagine that that's going to affect one of our clients doing an estate planning transaction. But the teeth in it is significant enough that you want to comply. There is an estate planning exception for requirements to file with the FTC. The last time I looked at it, which was some time ago, that exception was clearly written by someone that didn't understand estate planning, and it didn't really cover a lot of the common transactions that we do. So just be mindful when you're working on a large transaction to address whether or not there's a requirement to file under FTC. And that is one of those little esoteric niches that I think you want to go to a big firm that has FTC counsel. And most of these folks seem, every time I've hired somebody or worked with somebody, they're all based in DC where the government agencies are. So that's a quick little snippet, but be really, really important. If a client did a large transaction and you didn't address it, I would still go out and get FTC counsel to review it and see if there's a way out of it, or at least alert the client to what could be. Alan?
Wow, I had no idea. Never heard of that. Is that
I don't think very. I
something
don't.
that became apparent?
When I was a young lawyer, when I had dark, full head of hair, I can't even remember when that was. I worked in a firm where we did estate and tax and corporate work in a boutique, and the Hart-Scott-Rodino, that's what you want to look at, Hart-Scott-Rodino Act is where this comes up. So do look into it. If you have existing transactions, I would talk to somebody, and I'm going to try to do a webinar with an FTC expert, because even though it may not affect a lot of people, lots of attorneys see, an occasional large transaction, even if that's not the norm of what they do in practice. So I'll try to do a follow-up and get some real detail for everyone on that. So that was something on mind. Alan?
Now clients are coming in and saying, I have a grandmother, she's 92 years old. Can I somehow use her to get a basis step up with my assets? I heard there was a way to do that. So is the standard of practice now becoming, I've got to ask my clients if they have elderly or family members with short life expectancies, and explaining how to get a step up and how to leverage that? Is that going to be the new standard of practice? It's certainly something interesting. Oh, your grandmother's still alive? I hope she's having a great Christmas. Would you like a step up on her death? Is that the Christmas party conversation that we're looking for here?
First, that is not a standard of practice. I don't think it ever will be a standard of practice, and I don't want to have somebody from some plaintiff's counsel watching this and saying, oh, now I got him. So it's not a standard of practice. We do, is I think many estate planners do, a family tree for everybody. So we always try to go back at least to the parents, and if we can, even to the grandparents. One of the reasons I've done that, and it doesn't happen very often, but if there's like an Armageddon event and you need to hire an air search company to figure out who's getting, under the remainder, the more information you have, the better. The other reason I like to get a broader family tree is I like to get, at least if I can, and some people are very difficult, don't know or don't want to tell you, beyond the people named in the document, so that it's apparent if something is amiss, or they're giving money to one niece and not the other niece, etc. So I try to get the family tree. When we have elderly parents, I ask, are you supporting them? Are you getting giving them any financial help? And a lot of times, a lot of people do. And bringing up the basis planning is certainly something that it could be very advantageous to the client. I'm a little concerned with how far that's getting pushed and what might ultimately in the future change about it. But I think you'll agree, Alan, it seems to be what the law provides right now.
It's right in the statute.
So let me ask you a question. This is non-rehearsed. I have somebody who came to me exactly for that, and they own crypto. So trust companies that I contacted won't hold crypto. They say put it in an LLC and direct us to hold the LLC. We'll do that. But here's one of the questions, and I don't know if there's an answer to it. Can you make a completed gift of crypto? What do I mean? The struggle I have is if the client has the keys for the private wallet, unless they want to give that information to somebody else, can they really hold it? Does their holding that information now in the capacity of a manager under fiduciary obligation to an LLC and an investment advisor to a trust, is that sufficient to constitute a completed gift? Or is there an argument that they haven't really given up dominion and control to make that completed gift? And see, it's kind of almost like the old bearer bonds. Whoever holds it's got it. If somebody has those keys, they can take the crypto and it's gone. So I can't imagine a client comfortably giving somebody the keys. So you could do a multi-signature wallet where you have three people and each own, know a third of the keys, but the client still knows all the key from when he had it. So do you have to put it into a new wallet that's created by the trust? So getting a basis step up, especially with crypto, can be kind of complicated. And I'm not sure there's a lot out there. I've been reading everything I can find. I think it's still a little bit of the Wild West.
Well, isn't there an old Supreme Court case, Moline, is it, where you have a nominee, a principal, and if you if you give me $10 and I accept the $10 and agree that I'm going to hold this $2 million worth of crypto for your LLC as nominee, and that I will follow all of your instructions. Well, I'm bound under the law of all 50 states, I'm sure, to hold that only for you, and it's yours. I'm just holding it for you. So
But
I don't think
who is that person? Is that the donor or somebody else?
whoever has the legal right and possession of the crypto is now beholden to the LLC. So I would say certainly worth a try. I can't imagine
So
that state law would not give you a judgment if you went to enforce the contract.
so you, Alan, create an LLC that is owned 100% by a trust that you, Alan, created. You're the investment advisor or investment trustee of that trust. You're the manager of the LLC. You make a gift to the LLC. And just to backstop it a step further, in addition to making the gift, you sign a nominee agreement saying that you personally, wait, how do we do that? That you personally are holding the key only on behalf of the LLC because you don't own it.
Right. I transfer all right of ownership and direction and control and benefit to the LLC.
I think that's a good faith effort to show that you've made a transfer. I'm a little concerned about what issue you may face in terms of did you give up dominion and control? Because you still know the key.
Right. Well, you can go to the articles written by David Handler on his derivative contracts, and we just did a fairly large derivative contract for the owner of a law firm. The owner of the law firm said, "I can't give my law firm to this trust, but I can give this trust the economic rights associated with my law firm." And David helped us draft a fairly complicated agreement which puts the rights of the law firm owner, the economic rights of the law firm owner relating to the law firm, into a trust.
That's an interesting analogy.
That would be the way to do it. And he has
Yeah.
a lot of support in his articles. So I think that's where I would look to.
So the bottom line is there's getting the basis step up by giving a GPOA to an elderly family member is a great planning tool. I'm seeing it used more and more and more. I'm seeing more clients coming in just asking about it. And we'll figure out what to do in the crypto world, but it certainly is a little more complicated than your typical basis step up trust.
Absolutely. And at the same
What
time,
else?
let's not forget that a married couple would like to have a full step up on the first death. So they have the
You
ability.
just, don't you?
Yeah, right. So they have the ability to use a community property trust or a joint exempt step up trust, or call me when you know who's going to die first so I can put the assets.
Yeah, that sounds real practical.
Right. One of those things, but it's just something to keep the radar on.
Let me make a comment to set it up for you, and then you should explain the jest because I don't think very many people are familiar with it. So comment, I've talked to a surprising number of practitioners in non-community property states who feel that if they set up in a non-community property state a joint single revocable trust, that if either spouse dies, there's a full step up. I don't see any support or basis for that. But that same trust could be tweaked and turned into the jest that Alan's going to describe, where there's an argument that will get you the full basis step up. Let me also say that these joint revocable trusts in non-community property states, every time I've encountered one, I've never created one. There's problems with them. There's problems of who really owned what. There's problems when large gifts are made. They've been very nettlesome and they concern me. But in those cases, they've been almost used as a default by really a draftsperson that I think is getting forms from some provider and just doing them. And that you need to be very careful of. What Alan is going to explain, because I don't think most people will understand it if you don't explain it, is that if you intentionally create a joint revocable trust with certain tweaks he's going to explain to you, there's a position to argue that there is full basis step up on the first death. So I would differentiate the jest that's done purposefully and intentionally that Alan's going to explain from a form joint trust that's being just used in a non-community property state without great thought. Alan, why don't you explain the jest?
Yeah, well, first of all, I'm going to say I've been hired as an expert witness at least 2 times I can remember where decent lawyers have gotten hold of a joint trust form and just messed it up. If you're going to do a joint trust, you've got to read every single sentence in that trust because it's never clear. It's usually not clear. What if one of us dies? What if one of us becomes incapacitated? Or does this happen on only the second death? So you've got to be real careful there. There's just a lot of malpractice. It's an easy place to make mistakes. Joint
And they're
trust
not always obvious when you're doing them.
they're not obvious when you're doing them. That's right. Or at least have a trust protector who can clean it up later if no one's sure what you meant. But the question here is, or the history of this is in 1999, 2000, and 2002, the IRS released 2 private letter rulings and 1 technical advisory memorandum that said if you have a married couple in a non-community property state and one of them dies and has a power to direct assets to at least creditors of their estate, then that power can be used to fund a credit shelter trust from the joint trust, which will be considered as created by the first dying spouse. So if Marcia and I have 20 million worth of assets and we have 15 million each of exemption, the one of us who dies first could cause 15 million of assets from our joint trust to form a credit shelter trust. And the IRS said that's fine. So the next thing the IRS says in these rulings is, but you don't get a step up. And the reason you don't get a step up is under 1014, if you give something to someone and they give it back to you within a year by death, you don't get a step up. And what you've done here is Marcia gave Alan the right to a power of appointment. He died, exercised the power of appointment to a credit shelter trust for Marcia. She got it back within a year. She got it back in an instant. And that was their rationale. So I talked to Howard Zaritsky about that. I said, Howard, a credit shelter trust is not the same as getting it back within a year. A credit shelter trust is, you only get it as you need it for health, education, maintenance, and support after taking into account other assets. He said it's not safe.
You can name an independent trustee.
Right, right. And it comes to mind, Marty, what happened was the statute says you get it back within a year, and then the IRS does these regulations that say, well, if it benefits you whatsoever, it's like you got it back within a year. Probably those regulations are not valid now that we know. Yeah. But anyway, so what the Jest Trust says is when Alan dies, Marcia's not a beneficiary of the Credit Shelter Trust unless the trust protectors allow her later on, install her as a beneficiary of the Credit Shelter Trust. Now, I personally don't even think that that's necessary. I don't think the regulations are valid, but if you want to step up, then you just put together a joint trust and you give the first dying spouse the power of appointment. That those assets go to a trust that benefit the descendants, but not the surviving spouse, unless an independent third party later puts causes that spouse to become a beneficiary. And if you want to be super safe, put that they can't even do that unless and until the surviving spouse needs that. So 2 purposes of the joint trust here. 1, get a fully funded credit shelter trust. You've got 2 doctors, they're earning great money, they're clearly going to be estate taxable, but now they only have 15 million of assets total. Now you've funded that full credit shelter trust on the first death. Secondly, hopefully a step up, and why not go for it?
Yeah, we had a conversation with Jonathan Blotmacher. He seemed unconvinced that it would work. I think his issue was the part of the assets that you put into the joint trust are in your estate because you transfer them and you retain control under 2036, 2038. The other part that you have a GPA over, his issue was that, well, gee, Marcia, your spouse, kind of owns those, can you really have a GPOA over an asset that somebody else still owns? It's almost like two owners. But that seems to be common in a lot of the GPOA planning that people do.
Right. Well,
But
Jonathan certainly prefers the community property trust, and it's stronger. The community property trust is
yes,
safer than the just, but you've got to go find a trustee in a community property state to do a community
and some
property.
clients don't want to do it.
Clients don't want to do it. And then the creditors, if you do an Alaska community property trust and one spouse gets sued, the creditors can reach everything in the community property trust. So there's pros and cons, but plenty of things to think about.
No, it's certainly interesting, and but again, for practitioners that are doing joint trusts in non-community property states, thinking they're getting a basis step up, you should shift to the just, because at least it gives you a better argument that you do get that full step up. The mere use of a standard boilerplate kind of joint trust, I don't think works.
Agreed.
You want to do one last quick topic?
Sure. What have you got?
So one of the things that when we have conversations with clients, and I'm gonna tell a little personal story because it's the only way to really illustrate this. When we're planning with clients and clients say, oh yeah, I probably won't need that money, I'm still working, or I got other money, and they're comfortable putting X millions of dollars into a slat, we need to really address, is a slat enough? Or I'm going to do a dynasty trust for my kids. You know, there's often talk, don't do non-reciprocal slats, do a dynasty trust for one and do a slat for the other, because clearly if a spouse isn't a beneficiary, there's no issue on reciprocal trust doctrine. I think there's a piece of that conversation that doesn't happen that really should happen. So my wife was diagnosed about 20 years ago with MS, and it's been an ongoing 20-year struggle with insurance companies and drug companies. It's you know, I'm not going to get into it, but it's awful the way our country treats and handles these things. Last year, after being on the same therapeutic drug for 13 years, and both her neurologist and she are comfortable with it, that it's working, and they want to continue it, the insurance no longer covers that particular drug, but they suggested other drugs. Those other drugs, because of a antibody that my wife has, won't go into the details, the side effect of the drugs they recommended is death. That's a material side effect. And they don't give a flying petunia about that. And it's in the records, it's in her medical charts, but you're dealing with a clerk looking at a computer screen, not a physician making these decisions. So they denied coverage. It took us 3 months of fighting back and forth, struggling, doctor's requests, letters, and had my wife not been if my wife was not a physician to be able to really translate and understand all the medical nuances that were going on, I don't think I could have, with all my legal background, gotten this resolved. She managed to get it resolved. The out-of-pocket cost last year, had they not resolved it for her medication, was 150 grand a year. Now, when we're doing planning for clients, we need to think about future uncertainties that the clients aren't contemplating. The incidence of chronic disease grows pretty exponentially as you get on in years. In your 70s, there's a much greater likelihood. And there's 150 million Americans living with chronic disease. And in a large number of those cases, it has a material impact on them. This year, same thing. Why give her the drug that was approved last year? Nothing's changed. You would think the same approval would apply, but no. Same denial. We got to go through the same multi-month process, and we're not assured we're going to get it. So when I created non-reciprocal slats in 2012, for all the reasons that everyone else did it in 2012, because you know the exemption is going to drop to $1 million, and it all made sense to do. I didn't know what I know now. If I were to redo my own trust, if I were to do them now, I would put in more access, not less access. I don't think I would want to do a dynasty trust for a client if instead I could do a slat. Maybe what I would do is one hybrid DAPT and one SPAT, special power of appointment trust, where Alan could appoint money to me, and a hybrid DAP where a friend of my wife could add her back as a beneficiary. I think we need to really think carefully about what the medical and health and other life uncertainties, life is not certain, can bring down the road. Because I think it's safer for a lot of clients, even if they don't feel now that they need it. Are they really contemplating what potential health and other issues can cause them? I've had conversations with multiple friends and colleagues over the last week. It's just been a bad week for these conversations, where spouses are in care facilities, and because of the lack of care in a care facility, they're all hiring. They've all hired, everyone I've talked to, 24/7 private nursing care on top of whatever the supposed nursing home or care facility provides. Very costly, especially if you don't have any long-term care coverage to cover any of it. So I think when we're doing the kind of analysis that we do and helping structure the trusts, I think it's important to say to the clients, have you really contemplated what some of the uncertainties could do to you? If a client, even with pretty significant wealth, has to pay an extra unanticipated 150 grand a year for private nurses or medicine that they need to survive, that can be a burden on even a pretty wealthy client. So I think when you're doing the analysis of the type of trust structures, don't just simply knee-jerk do non-reciprocal slats or one slat and one dynasty trust. I really think broader access, putting in loan provisions, right? Putting in a SPAT provision, a hybrid DAP provision, is really going to help a certain number of clients that don't anticipate what might be coming down the road. Alan?
That's a good point. And Marty, that's one reason that I'm not in love with Roth conversions for people who are not super wealthy, because that IRA money might be used to provide that care tax deductible. So
Oh,
if
interesting thought.
I ever needed 300,000 a year for 10 years for nursing care, I could pull 3 million out of my taxable IRA and pay no tax on it.
Because you're offsetting it with a medical deduction?
Yeah. Mm-hmm.
What about all the phase outs and stuff? Isn't there like a 7.5% of AGI?
Yeah, but 7.5% of AGI won't be that big of a problem when you're spending $300,000 a year on
A
medical.
year.
So you only lose 21,000 of it.
So
But
what?
I think before you have anyone do a Roth conversion, you make sure they have plenty for nursing care for their lifetime, and that's a
Yeah,
bigger concern than the tax on the IRA.
that's a very clever point, and it's consistent with what I was trying to say. I think we need to really think about the what ifs and the unknowns, and tell clients to think about it, because this is not nobody wants to think about this. Nobody. It's not pleasant to think about, but it's real. Alan, I think we're at an hour.
Yeah.
Do you want to summarize or leave us with any words of wisdom?
Well, I think we live in a very interesting profession and a very interesting time with technology coming along and clients learning more about what we do than they used to know. This is a great time to be a tax and estate planning advisor. And
I think that's true. I'm a little frustrated and concerned that clients are thinking they know what we do by asking AI and they're not getting good answers. So that's going to be a challenge. But I think part of the challenge for many people is we're all busy as can be. We're all stressed with time. You know, we all have to do billable hours and yada yada. But we need to, quoting, Stephen Covey's 7 Habits of Highly Effective People, we got to take time to sharpen the saw. And in this day and age, at this particular point in time, I think one of the most important saw sharpenings is learning how to use the technology, the AI, the drafting software, the projection software, all the stuff that's out there. And whatever's out there in a year or two, and certainly in 5 years, is going to be exponentially more powerful than what we have now. So you really have to take the time to start riding that wave, or I don't know how you're going to practice effectively.
It certainly helps to use that stuff. It's nice to have. It's like,
So
remember we used to drive with a map before GPS, and where am I? How am I going to get there? Now the software is really taking us places for sure.
It's amazing how dependent we are on that. I used to always have maps, and I was pretty good at reading maps and figuring out. And before I went someplace, I would do it. You're too young, but when I would go on a road trip, I would go to AAA and get their triptych so you could flip through
Yeah,
the maps. I don't know
yeah,
if you're old enough to remember that. And now it's like you don't drive to the supermarket without putting GPS on because you're just so like, the mindset is just, oh yeah, I'm going someplace, I'm putting it in GPS.
that's
So
right.
thank you everyone for joining us. This was sort of a wide-ranging discussion of potpourri of just disconnected different topics, but hopefully one or more of these points will be really helpful to you. If you've not been aware of the FTC issue, boy, you want that on your radar. The Powell and Moore challenge on a Wandry, I think is often overlooked. Mixing and matching different techniques like the King and a Wandry and a Petter, I'm blanking on the name of the other cases where you have a spillover to charity. Petter and Christensen.
Before.
Yeah, there's lots of different things that we should all be looking at. The administration of a Wandry, I agree with Alan. I don't think it's generally done, so it's certainly not a standard of practice. But I think the more we can do to adhere to formalities, the better our clients will fare when there's a creditor or IRS challenge. And we're going to have a new dawn of AI audits that I think will potentially change how we all look at things.
Yeah,
So hopefully this was helpful. Enjoy your holidays. Have a great year end, and we'll see everyone at Heckerling, I guess.
that's right.
Be
Thanks,
well,
Mike.
everyone. Take care. Thank you, Alan.